my lord, my lady, three quick points arising out of this morning. The first point is that I think I was asked whether there was anything which sort of connected a consideration of old cases and common law with section 29 of the Act. Though we do have a section of the digest on the law of partnership by Lord Pollock. That's at tab 83, so volume 5, and at page 2257, he was, of course, the drafter of the Partnership Act, and I believe Lord Linley's pupil. And he says, in relation to the Act, that when such a digest is used as the groundwork of a bill, and the bill finally becomes an Act of Parliament, as happened with Judge Chalmers' digest of the law of bills of exchange, and later with the present work, the decisions exhibited by way of illustration are no longer the only part of the work having authority, but they remain authoritative so far as they are consistent with the terms of the Act. And a summary, a view of them, will often be convenient, sometimes almost necessary, for the understanding of the law as now declared by the legislature. And if we could just also go to tab 81, which was the treatise on the law of partnership by Lord Linley, and where he said that effectively, this is at page 2251, it's tab 81, and at page 2251, internal page 74, he sets out section 29, and he says in the commentary, this section introduces no change into the previous law. The foundation of the rule is the relation of agency which exists between a partner and the firm, and the good faith which is required in all transactions between partners. This section will include cases in which a partner seeks to derive a profit from some transaction between himself and the firm, as for instance by selling his own property to the firm or making a secret profit, cases in which a partner attempts to obtain to himself a benefit which it was his duty to obtain, if at all, for the firm, as for instance where a partner obtained for himself a renewal of the lease of the partnership property or abatement from encumbrances upon property which he was purchasing for the firm. So that's Lord Linley saying that it wasn't introducing any change to the previous law.
In terms of connection, that's at the top of the next page.
Yes. Cases in which a partner seeks to obtain a private profit from the use of partnership property or connection. Then my Lord Justice Snowden raised the question of the list of customers just before lunch. And of course, insofar as the list would be treated as confidential information, I don't think that we could disagree that that wouldn't be partnership and treated as partnership property. But the question will always be, has the partner, post-dissolution, made a profit by use of the list of customers, by use of the confidential list? If the partner never used the list, if, for example, the customer on the list was just known to him, and therefore he thought, well, I'll go and ask Fred Bloggs if he would like to buy, then obviously that wouldn't be, we say, a breach of fiduciary duty. In this regard, I was going to come on to it a bit later, but I can do it now. We rely on the case of Hunter Kane and Watkins, which is at tab 34 of the bundle, so volume 2. It's a case which has been cited with with approval in the Court of Appeal and in other courts. So the words probably are familiar with you, but it was a case where, and we refer to it at paragraph 50 of our skeleton. It's a case by Bernard Livesey QC, sitting as a High Court judge, summarised the position at paragraph 25 of the judgment as to what he thought a director would be permitted or precluded from obtaining for himself. And at paragraph 2 of that paragraph 25, so on page 590 of the PDF, he says, a requirement to avoid a conflict of duty and self-interest means that a director is precluded from obtaining for himself, either secretly or without the informed approval of the company, any property or business advantage either belonging to the company or for which it has been negotiating, especially where the director or officer is a participant in the negotiations. And then he went on to say, but paragraph 6, directors no less than employees, and we would say partners as well, acquire a general fund of skill, knowledge and expertise in the course of their work, which is plainly in the public interest that they should be free to exploit it in a new position. After ceasing the relationship by resignation or otherwise, a director is in general, and subject of course to any terms of the contract of employment, not prohibited from using his general fund of skill and knowledge, the stock in trade of the knowledge he's acquired while a director, even including things such as business contacts and personal connections made as a result of the directorship. So we rely on that in the context of partnership. Also, we point out now is, of course, that the judge made no finding that the partnership's relationship with ACON was what allowed Mr. Hughes to make a profit. So I addressed you on Don King just before lunch. Coming on to John Taylor's, that is sorry. That's at tab 30, volume 2, page 500 of the PDF. It concerned a 5-partner partnership at will. So saying this partnership was a partnership at will. It had been in existence for over 50 years. And it had the benefit of a number of licences over the years of premises from the East Lindsey District Council. The licences have been in existence since 1947. The licences, there were a series of licenses to carry on the business of livestock auctioneers. You get that from paragraph 4 of the judgment. The licence that was in existence at the relevant time was a 10-year licence, which was due to expire on the 31st of December 1998. 2 of the 5 partners gave notice to dissolve the partnership with effect from the 31st of December 1998, so the date when the licence terminated. Prior to the 31st of December, the local authority was interested in renewing the licence with the partnership, but the 2 partners who'd already decided that they were going to dissolve the partnership wrote to the council asking for a new licence to be granted to them alone. And the council granted them a provisional licence, and the 2 partners began to trade the livestock auctioneers in January 1999 with the benefit of that provisional licence. That's page 6. That's paragraph 6. The 2 partners then announced, prior to dissolution, to the partnership's customers that they would be running the market under a provisional licence. That's paragraph 7. And then subsequently, the two partners were granted a full licence as a consequence of a competitive tender, which the other three partners and another third party also participated in. The three remaining partners commenced an action, this is at paragraph 11, for relief on the basis of first, breach of fiduciary duty, second, section 29, and third, section 42. And the Court of Appeal held, Lady Justice Arden giving the main judgment, that the two partners were liable to account for the renewed licence. Lady Justice Arden, having referred to Don King, Parithana, Chan Zakaria, effectively pointed out, and the fiduciary duties relied on in those cases, which held that assets obtained following dissolution can constitute partnership property if the tests set out in Chan and Zakaria are satisfied. And Lady Justice Arden answered both tests in the affirmative, that's at paragraph 27 and 28, and went on to hold at paragraph 29 that the essential steps in the argument were first, the opportunity to renew the licence was an asset of the partnership property. That's not surprising, bearing in mind that the licence was in existence all the way down to dissolution, and that there had been repeated licences since 1947. Second, the relationship that the old partnership had with ELDC was a business connection for the purposes of section 29. And Lady Justice Arden didn't immediately explain why the ELDC was a business connection, but a bit later, if one goes on to paragraph 32, she said that, if you can just go there, yeah, she said that that the partnership had an opportunity to renew the licence by reason of its relationship with the council, which was of very long-standing nature, from which it can be inferred, I suggest, that she would not have been persuaded that the EDLC was a business connection of the partnership if the partnership relationship with the council had not been of a very long-standing nature. Third, all the assets of the partnership, she said, have to be brought into account and divided between the partners at dissolution, and the winding up of the partnership can't be said to be completed unless this has happened. And fourth, the duty to account imposed on a partner extends to assets which have come into existence and prior to completion of the winding up by reason of the maturation of some business opportunity in existence at the date of dissolution, because such opportunities are obtained in a situation of conflict of interest and duty. Returning to the first step, where Lady Justice Arden declared that the opportunity to renew the licence was an asset of the partnership, if what she said as the fourth step is added into the mix, it's clear that she regarded the opportunity to renew the licence as a maturing business opportunity, which of course it was, because the council had already opened negotiations for a new licence before the partnership had been dissolved. And the two partners applied for a provisional licence from EDLC before they dissolved the partnership. Pausing there to remind your lordships of the finding of the learned judge in this case, that the Danish deal was not a maturing business opportunity, and the point that I made earlier, that of the oddity that while the Danish deal was not a maturing business opportunity, Mr. Hughes is still obliged to account for the profits on the deal to the extent that they were derived from the partnership's property, name or business connections. The fifth point that Lady Justice Arden made is that section 29 provides that the partner is accountable for any benefit derived without the consent of the partners from the use of partnership property or business connection. And sixth, importantly, the two partners were accountable for the benefit of the goodwill they had appropriated to themselves and for the profits attributable to or the benefits derived from the use of assets of the partnership, including its goodwill. And again, pausing there was no finding by the learned judge that Mr. Hughes and MSDL could only purchase from ACON because of the partnership's goodwill with ACON. As I said before, the judge did not find that ACON was part of the partnership's goodwill. And then we come on to Woodfull and Lindsley, which is another case where Lady Justice Arden gave the main judgment. This was a retirement, and this is at tab 36.
So we've moved bundle around to...
Yes, I do apologise. This is tab 36. So volume 2, it was a retirement rather than a dissolution case. But it is nonetheless instructive because Lady Justice Arden approached it in much the same way as she did John Taylor's. It concerned a 3-partner firm, which had lasted for 6 years. A year before Mr. Woodfull retired, he was negotiating with a company called Colt for a contract for the partnership on terms that there would be an option to renew. That's at the facts are set out at paragraph 14. Colt represented 1/3 of the partnership's turnover. Instead of obtaining the contract for the firm, Mr. Woodfull incorporated a company, Time and Place, which immediately obtained a 12-month contract with Colt with the possibility of renewal. And some 4 months later, Mr. Woodfull retired. The result of the case was unusual because of the finding that the 2 remaining partners had waived their right to recover profits on the Colt contract and any subsequent renewals after Mr. Woodfull's retirement date in September. But subject to that finding, actually we can look at Lord Justice Norse's judgment at paragraph 17 of the judgment, page 613 of the PDF, 630, sorry, of the PDF. Where he accepted as correct the submission for the 2 remaining partners, namely that the partner who appropriated the opportunity prior to his retirement was obliged to account for it.
Sorry,
Lady Justice Arden.
Where are we reading from?
This is paragraph 17, internal number 137.
Or is there a conclusion here?
Sorry?
Is this just a reciting of submissions or is it a conclusion?
I think he accepted, had it not been for the agreement, this is the last part of paragraph 117, the agreement for Mr. Woodfull's retirement and its subsequent affirmation, I would, by an application of principles hereafter, refer to it as correct. Yeah. Lady Justice Arden put the position more starkly. Paragraph 28. Where she said on that basis, this is at page 633 of the PDF, Mr. Woodfull must, in my judgment, be accountable to the partnership for the profits earned by Time and Place from the Colt contract.
Sorry, which paragraph?
This is, sorry, paragraph 28. What she's doing in that paragraph is pointing out that but for the waiver by the other partners, Mr. Woodfull and Time and Place would have been liable to account for the renewal of the contract, even though there was not an absolute right of renewal. And as you go through, in support of her findings, she relies on Don King and John Taylor's. Paragraph 28. And so the point that we draw out of this case is that it's another one where the partner appropriated for himself, while the partnership was still subsisting, a contract that would otherwise have been available to the partnership. And then the final case that we refer to, because these are all cases of sort of post, well, Woodfull wasn't a post-dissolution requirement to account. That's the one exception, but they're all cases where, in Mr. Woodfull's case, it was retirement. All the other cases are post-dissolution where the courts have found that there is a duty to account. And what we draw from all these cases is that in each of these cases, the partner pre-dissolution was trying to, and did succeed in leveraging for himself a contract that would otherwise have been available to the partnership. And that McGill and Huang was a 4-partner firm. It was a judgment of His Honour Judge Kramer.
Sorry, where are we?
This is at tab 55.
So that's a different.
Yeah, that's volume 2 again, same volume.
I don't. No, not in mine. Not if
Oh,
it's tab 55.
Oh, it's not 55 for you, my
Sorry,
lord.
what tab is it?
I think it's tab 55, McGill and Huang.
I see. That's volume end of volume 3.
Oh, sorry. Oh, yes, you're right. It's the last one. Yes. So it was a 4-partner firm that lasted for a few months.
It's number 4 for me.
Oh, no.
Sorry.
Sorry, I think my clerks were photocopying. I think they might have not got it quite right. I do apologise. So the partners purchased from a company called Lagardère the rights to advertise on display boards at football clubs and sold the rights to an agent, Tomorrow Sunshine, for substantial sums. Mr. Huang dissolved the partnership in December 2016, but prior to dissolution of the partnership in November 2016, this you get from paragraph 93 of the judgment, he was negotiating with Lagardère for a renewal contract for the partnership. You can again see that in paragraphs 93 again and paragraph 126. And he was negotiating for the rights again for a third very similar and lucrative contract with a possible profit of about 1.94 million to display advertising at football clubs that he would then go on and sell to Tomorrow Sunshine. Post-dissolution, Huang entered into essentially the same contract that he was negotiating for the partnership in November 2016 through his company that time and sold the rights to Tomorrow Sunshine. That's, you see that at paragraph 107. The case is again somewhat unusual because the court found that the partners had agreed that one of the former partners would be responsible for sharing his profit with the 2 other former partners from the contract Mr. Huang entered into post-dissolution. You can see that from paragraph 130. But nevertheless, His Honour Judge Kramer set out the principles that would have otherwise applied absent that agreement at paragraph 128. And unsurprisingly, he concluded that Mr. Huang would have been under a duty to account for the profits of the contract, which had been discussed at the meeting with Lagardère prior to dissolution, because he found it was secured on the back of the goodwill that had been generated by the previous contracts entered into by the partnership. And we don't disagree that goodwill is obviously partnership property, and that a renewal contract negotiated for during the subsistence of the partnership when goodwill still existed and when Mr. Huang's fiduciary duty as a partner still applied, would be something for which he would be required to account. The point about these cases is that they all concern claims for an account for post-dissolution benefit, which, as is at the heart of this appeal, the account is for what is treated by each court as partnership property or analogous to partnership property, having been negotiated for during the subsistence of the partnership. And it's notable, we say, that each case concerned a substantial contract that was exclusive in the sense that there was only one premises, only one licence, only one Tomorrow Sunshine to which one could negotiate and sell the particular contract to advertise on football pitches. Or in the case of Woodfull, McGill and Donking, only one contract or series of contracts available. Each case either concerned contracts in existence at the date of the dissolution, or the partner was negotiating for the benefit of himself alone a renewal of a contract that existed prior to dissolution. And we say that in those circumstances, the breach of fiduciary duty was obvious. And the examples were Pathirana, Chan and Sakaria, and John Taylor's. If there had been a contract that had expired and the partner negotiated prior to dissolution for a new contract or renewal contract for the benefit of himself alone, Woodfull and Lindsay and McGill and Huang are examples of where the court would require the partner to account, because the negotiation was done on the basis that he was a partner, and yet the contract was entered into post-dissolution. And in the case of Don King, the contracts were in existence at the date of dissolution, and post-dissolution, the partner was claiming to take the benefit of those contracts that were still in existence at dissolution, because his position was the partnership has come to an end, so I should be able to walk away with those contracts. But importantly, the court also held that if you renew those contracts post-dissolution, because they were of contracts that were in existence pre-dissolution, you have to account for them. Drawing together the reasoning of those cases, what we say is a partner is obliged to account for post-dissolution profits derived by him from use by him.
Sorry, this sounds important. So let's get the partner is obliged
to account for post-dissolution benefits or profits derived by him from use by him.
Hang on, by him.
Yeah, by him.
From use by him.
So obliged to account for post-dissolution benefits stroke profits derived by him from use by him of partnership property, name or business connection during the subsistence of the partnership. Which he's so by negotiation for a new or renewal contract on the back of that partnership property. So he engages in negotiations pre-dissolution for a new contract, which he is then able to exploit post-dissolution.
But in just take the renewal case,
Yes.
in Don King isn't quite within that.
Well, it is, because the contracts themselves were in existence at the date of dissolution. They carried on post-dissolution. They didn't. Mr. Warren was arguing, oh well, because our partnership is at an end, these promotion and management agreements with my boxers are also at an end. But the court said no, the agreements carry on.
So you put that in your statement of principle, you put that as being those are the partnership property.
Yes.
Existing contract.
Yeah, and the right to renewal, because a promotion and management agreement with a boxer inevitably carries a likelihood that the boxer will want to renew the agreement with the promoter, that carries with it some goodwill, which the court said that you had to bring into account. And there's no surprise about that. I mean, first of all, the agreements were in force at the date of dissolution and carried on. And secondly, these were almost what one might call relational contracts between a boxer and Mr. Warren. And of course, they had the quality of being a strong relationship. And there was a real prospect that a boxer already having a agreement with Mr. Warren, which lasted in the first instance for 3 years with an opportunity to carry on for another 18 months, would carry with it, you know, a significant degree of goodwill.
Okay, thank you.
Can I just clarify? I'll make sure I've got this written down correctly.
Yeah.
I wrote down the partner, or an ex-partner, in fact, must account for post-dissolution benefits
Mm-hmm.
derived by him from use by him of partnership property, name or business connection.
Yeah.
During the subsistence of the partnership.
Yes. Or you could say from use by him during the subsistence of the partnership.
That was going to be my
Yeah.
question. So is it? So I understand that if we're always talking here about post-dissolution benefits. So I understand
Yes.
that. Is it so you accept that if you during the subsistence of the partnership use partnership property, name and business connection, the fact that you don't receive the benefit until afterwards doesn't matter.
Yes.
You still have to account.
Yes.
But what about? I just want to get clear what your submission is. If you have something which is identifiably partnership property, name or business
Mhm.
connection, but you don't use it until after the dissolution
Mm-hmm.
to make benefits, do you have to account for that?
Yes, you do, and I think that's what Section 29(2) is talking about. That's because Section 29(2), go back to Partnership Act.
So does it matter, in fact, when you use it? You're just saying it doesn't matter when you use them. The critical question is it partnership property? Well, the timing doesn't matter. The critical question is, are you using something which is identifiable as partnership property, name or business connection?
Yes, and if
It doesn't matter. It doesn't matter when you receive the benefits, and it doesn't matter when you use it.
and if the transaction doesn't get completed until after dissolution, you would still have to account, and that's what Section 29.
Okay,
is
but
talking about.
if you have something which it was within the definition of partnership property, you just happen to be hanging on to it after dissolution,
Mm,
you would accept you can't just use it
No.
to make a profit.
no.
So obviously you can't use the partnership name after dissolution to make a profit
Mhm.
without having to account for it.
Mm-hmm.
So can you use a business connection of the partnership after dissolution without having to account for it?
If it's a business connection, no, obviously you would have to account for it. Yes,
Right, so the critical question is, what is a business connection of the partnership?
yes,
Which we're going to come on to. Is that
yes.
right?
My learned junior says that you're asking if the transaction doesn't start until after the dissolution. I think we've just
That is exactly what
Yeah,
I'm asking.
and
you,
I think
because
we've just
absolutely-
agreed that if the transaction doesn't start until after dissolution, there would still have to be an account for it. If it is partnership property name, if the partner is seeking to derive a benefit from the partnership name, partnership property name or business connection. Yeah.
Even if they don't start trying to do
Yes.
that until after, but that presupposes that they are able in some way to have access to, I'm trying to use neutral words,
Yeah.
have access to property, and the obvious example is somebody just holds on to it
Yes.
because it's a thing,
Mhm.
or uses the name,
Yes.
because they use the name, use a
Yeah.
head or whatever. And you accept that if it's properly within the concept of a business connection, whatever that means,
Uh-huh.
then the fact you don't start using it until after the dissolution doesn't make a difference.
I do accept that. I think really why I was taking you to all those cases is to show you how the courts have approached opportunities negotiated for by a partner.
But this is, I haven't mentioned the word opportunity. And
Well, no, I know, but or new contracts negotiated for by a partner.
if ACON does properly come within the concept of a business connection.
Well, I haven't got hope. But
That's candid.
well, if you're going to say ACON is a business connection,
Well,
we
it
clearly
does focus on that rather important question as to what does business connection mean in the context of Section 29.
Well, and I did take you to John Taylor's, where that was a case where Lady Justice Arden said that the partnership's relationship with EDLC was a business connection, but the criteria that she used for it were entirely different for the criteria that were in existence between Mr. Hughes and ACON in this case.
Just for me, I mean, have you got onto this set of submissions yet? I mean, have I sort of missed the depth?
No, you haven't missed the. No, we're getting there.
That's fine. No. I'm eagerly awaiting it. I'm just was pleased to hear I hadn't missed it.
Well, at risk of stating the obvious, obviously what we would say, because we say Section 29 is the statutory manifestation of the fiduciary duty, it has to be demonstrated that when if a partner exploits what was a business connection of the partnership, that in order to account, he has to have breached his fiduciary duty for that purpose. So in other words, it's possible that one can have a situation where a partner uses a former business connection of the partnership, but it's not a Section 29 obligation to account case because he hasn't breached his fiduciary duty in doing so.
I'm just trying to think of that scenario. So it's a business connection in terms of a customer, let's say.
Yes.
And which is undoubtedly a business connection, and it's undoubtedly
and the partnership hasn't been wound up.
It's an opportunity property of the partnership, but he says to each of the other partners, can I pursue that opportunity for myself?
Yeah.
They all say yes.
That's all right.
Fully informed consent, not a breach of fiduciary duty. You're saying you can't run around the back of that using Section 29.
No. But supposing that the partnership had a business connection, but the partner was able to say, well, actually, the profit that I derived was not by using the particular supplier as a business connection of the partnership, but was because I had my own relationship with the supplier. And so the generation of the profit wasn't by use of the supplier as a business connection of the partnership, but was as a consequence of my own relationship with the partnership. With the supplier.
Actually, my example wasn't a good one because the concept of consent appears in both Section 29 and fiduciary duty. So scrap that. Okay.
I mean, Lady Justice Arden talks about business connections as being assets of the partnership.
Yes.
So maybe the pertinent question is, are you really using an asset of the partnership?
Yeah.
Or are you using, for example, your own?
Yes. Well, that's
personal
connection.
with that particular supplier.
Yes. Which goes back to the case that I referred to, Hunter Kane, where Hunter Kane, not Hunter Kane himself, where Bernard Livesey, QC, referred to directors, and we would say partners, being able to use post-resignation or post-dissolution their general fund of skill and knowledge, including things such as business contacts and personal connections made as a result of his directorship.
Yes, I suppose a modern example of that might be a LinkedIn profile where you've built that up as director of company X.
That's a difficult one, isn't it?
Well,
Yeah.
It may show how difficult this point is.
Well, yes.
But some might say, well, in fact, that's a personal, the details on that.
Yes.
The LinkedIn connections are now personal.
So we essentially set out our complaint in paragraph 5 of ground 1B of the grounds of appeal. That's in the core bundle, page 17, where we say that the judge should have held, and this was really the point that I was just making to my Lord Justice Snowden, that there can be no liability under section 29 for post-dissolution benefits and profits if those benefits and profits involve no conflict of interest and don't involve any exploitation of the partner's fiduciary position. And the judge never looked at it that way. I mean, his approach was simply look at section 29. If I find that that a business connection means it is, as a matter of law, a supplier like Acon, you have to account, irrespective of the fact that there was evidence to suggest that Mr. Hughes was supplied by Acon, because Acon liked him and didn't like Mr. Manduka. And also, as I've said before, by the time of the dissolution, any enthusiasm that Acon had to supply the partnership had evaporated.
Well, that's ground 1C.
Yes.
Isn't
Yeah.
that part of 1C?
Yes, I'm coming on. I'm coming on to that. I won't. I know you. I'm getting there.
No, but your last bit you slipped in there was.
Yes.
Is that really a ground 1B point?
No, it's not. But it sort of fitted into the question of whether simply using a business connection, but by a partner, inevitably leads. A business connection of the partnership by a partner inevitably leads to a duty to account if, when the partner uses that connection, it's not sort of leveraged as the partnership's relationship.
Yeah, that's a bit problematic from a company law point perspective, isn't it? Because if you have, as a director of a company, so the company has a relationship with a client, it's no answer for a claim for breach of fiduciary duty ever to say, well, as a matter of fact, the company couldn't or wouldn't have done any more business with that client because they like me.
Yeah. Well, if it's
me. I mean, that's the classic
yes.
plea of a director who takes for himself a company client.
Well, except that there are circumstances, clearly, because that's what Bernard Livesey said, and I mean that sentiment has.
In fact, I mean, I think the law is that if the opportunity comes to you as a director, it's not even a defence to say actually the company couldn't take it.
No, that's right. That's right. But I mean, it's not.
So it's not really a 1B point. Sorry, I'm being just a bit anarchy about this, but your last bit that you slipped in is not a 1B point at all.
No. Oh well, I mean, it's not in 1B. It's in. I think it's in 1C because it's in paragraph 50.
You just sort of slipped it into 1B.
Yeah. Well, because it's sort of
mentally excited.
Yeah. Yes. Well, it fitted in at that point.
Or not.
Yeah. Yeah. Okay. If we could, so if we just go to tab 101 at the moment, it's an extract from To Me on Partnership. So it's 101.
Volume 6.
Where he expresses, I mean, I'm sorry, I'm still on 1C, but he expresses the view that on page, at paragraph 1535, page 2342 of the bundle. So he says, by its express terms, section 29(1) requires a partner to account for any transaction concerning the partnership or for any use by him of partnership property or business connection. Unlike the use of partnership property, I think it's not always so easy to identify use of the partnership name or business connection by a partner, which is a private profit under section 29. This is because in many partnerships, and particularly professional partnerships, the partners will be closely identified with their partnership, and therefore the business connection of the partnership will be partly due to the personal connections of the partners, and obviously partly due to the partnership. It follows that business may come from a former partner because of his personal attributes rather than because of his role as a partner in the firm, and therefore will not involve a use by him of the partnership connection or name under section 29. So I was just drawing your attention to section 29(2) with its emphasis on transactions undertaken after a transaction has been dissolved. What I say about that, is that the section 29(2), which of course has also been held to apply to where a partnership has been dissolved other than by the death of the partner. But section 29(2) refers to transactions undertaken after a partnership has been dissolved. And that is an echo back to section 29(1), which says that a partner must account to the firm for any benefit derived by him without the consent of the other partners from any transaction concerning the partnership. And then it goes on, or from any use by him of the partnership property name or business connection. And what we say is that when section 29(2) is referring to transactions undertaken after a partnership has been dissolved, it is relating back to the words transactions concerning the partnership, because you can have a transaction concerning the partnership which isn't consummated until the partnership has been dissolved. But section 29(2) makes clear that you still have to account for it. And in that regard, the judge did not find that there were any incompleted or incomplete transactions at the date of the dissolution, and therefore his only concentration was whether the ACON was a business connection. Now, at paragraph 259 of the judgment, the judge, in our submission, wrongly described.
Sorry, can I just clear the decks of it? The far 6 can go away.
Yes.
Just out of interest, do we have is O'Connor and Woods anywhere in the bundles?
I beg your pardon?
Is O'Connor and Woods anywhere to be found?
No, I think it's. We looked at most things, but that's one we'll look up.
It seems like it might be quite tricky to get hold of. It seems to be probably one of those.
Is it an English case?
Well, I don't know, you tell me, but it looks like it's an unreported.
Oh, it's an Irish. Yes. Oh, we looked for it, didn't we? I think yes, we did look for it. No, we weren't able to find it. We'll have another go, but I don't think we were able to find it for some reason. So
because there's something which, just looking at the facts, that's a former accountant,
yes,
partner in a firm, post dissolution, is approached by former clients of the firm.
yes.
clear that the decision is he's not liable
Yes.
under section 29 because even though those clients were previous clients of the firm,
Yeah.
even though, so the sort of question is on what basis is it said because they're not a business connection? Or is it said that it's because it wasn't a breach of fiduciary duty because he didn't approach them, they approached him? Or what? What's the basis for that decision as far as we can tell?
Well, it seems, looking at the first sentence, there was no enticement by him in connection with this work, and there was no obligation on him to leave work with the partnership, which he could do. It seems that maybe the emphasis is if the client comes to you and says, "Will you?"
Is the reason that he's not liable because he didn't commit a breach of fiduciary duty?
Yes.
And if so, well, is that because it was not a maturing business opportunity? There was no maturing business opportunity that he sought in breach of fiduciary duty to entice away. He was just approached after the event. Or is it because they weren't within the concept of a business connection for the purposes of section 29? Because it's curious that this seems to be under the heading, and it's difficult to tell, but it seems to be all to do with interpretation of
Section 29.
the concept of partnership name or business connection under section 29.
Yeah.
Anyway.
As I say, I think we did search for that case, but I don't think it revealed itself. So I was just coming on to paragraph 259, where the judge said, "I therefore do not accept Mr. Hughes' submission that he was no longer under any operative fiduciary obligation after he sent the dissolution email. He was at the very least obliged to account for benefits falling within section 9. And I need to make clear that that was not our submission and never has been our submission. Our submission was not, as the judge seemed to think, that subject to the reciprocity point, possibly, that Mr. Hughes no longer had any operative fiduciary obligation after he sent the dissolution email. Rather, the submission was that Mr. Hughes, like any other partner post-dissolution, was only required to account for transactions undertaken that concerned the partnership for the purposes of winding up, and also to the extent that he had partnership property, name, or business connection, he would need to account. So it wasn't that he was no longer under any operative fiduciary duty. We accept that he owed a fiduciary duty. And just to make good the point that I made earlier.
To be clear, you say he had a continuing fiduciary duty, but not to use partnership property for his own benefit, or a maturing business opportunity.
Yes.
For his own benefit.
Yes. Yeah.
You say the relationship with Acorn was neither.
Yes, exactly. And just to make good a point that I was making earlier, because section 4, paragraph 424, at page 172 of the core bundle, the judgment, he says
paragraph
424.
424.
He found that there was no suggestion that Mr. Hughes derived any benefit from a transaction concerning the partnership in the twilight period. So we really are just in the vicinity of partnership, property, name, and business connection. Now, at paragraph 56 of the Respondent's amended skeleton, that's at page 113. I think that the amended skeleton found its way into the agreed supplemental bundle. I expect you probably put it somewhere separate anyway. That they say for the first time, by amendment, made less than 6 weeks before this appeal, that Mr. Hughes' use of the partnership's goodwill, in particular its relationship with the sole supplier Acon, was an advantage he gained from his fiduciary position during the partnership. He was therefore obliged.
So I missed, where are you?
This is at paragraph 56 of the Respondents' amended skeleton. The Respondents amended their skeleton 6 weeks ago because I think Mr. Bayard was instructed in place of Mr. Gorgie. And at 56, paragraph 56, they make an amendment that JH's use of the partnership's goodwill, in particular its relationship with the sole supplier Acon, I just read it out. It's the second sentence. That was an amendment. Now, this is a new argument.
Can I just break it down so I understand where you disagree?
Right. JH's
suppose
use
we
of,
didn't leave out, suppose we left out the in particular bit, would you disagree? JH's use of the partnership's goodwill was an advantage he gained from his fiduciary position.
well, I disagree with all of that because it was never pleaded. It was never part of their case. They're pursuing this for the first time on appeal.
It raises the question, what do you mean by goodwill? And is there a finding that the goodwill of the partnership includes its relationship with the sole supplier Acon?
No.
Because goodwill is not a, I mean, that's
No.
your objection. Your objection, as I understand it, is whatever the relationship that exists between the partnership and Acon, it's not what is conventionally or otherwise referred to as goodwill.
That's one argument, but the second argument we have is they can't run an argument now, which was never pleaded. It was never part of their pleaded case. It was never advanced at trial. That Acon, because if they were going to run that argument, we may well have produced different evidence. We may have produced, I don't know, evidence from Acon to say, well, actually, although they thought that we had 4 suppliers, or 5 suppliers, we had 16 suppliers.
What do you mean by goodwill? I mean, goodwill is conventionally, we've seen it in one of the authorities this morning, goodwill is conventionally the tendency of customers, but not exclusively customers, to return to do business with the company. My understanding of your submission is that it's the other way around in this case. It's this company that has to go to Acon and ask for supplies.
Yes, yeah.
I mean, undoubtedly Acon might say, well, we've got goodwill because this company keeps coming to us for supplies. But that's not the point.
No.
And you, I think, further say, as I understand it, that if there was actually, if you looked at it, there would be a big factual question about whether the relationship between this company and Acon, sorry, I keep saying this company, I mean this
partnership, yeah.
Sorry, old habits die hard. This partnership and Acon, actually, there was very little good-natured dealings by the time of dissolution.
Yeah, yeah.
But you say in any event there's no findings on any of those things because it was never a...
No, it's never part of their case. I mean, you know, as we make clear in our skeleton, business connection was not part of their case until opening, and it probably was our fault for not jumping up and screaming and saying this was never pleaded that Acon was a business connection, but we got on with it, not least because the case had already been subjected to, the particulars of claim had already been subject to amendment 5 times. Yeah, well, it is what it is. But that was bad enough. But now to raise this point about goodwill at this stage, with no respondent's notice and no finding by the judge, that ACON was part of the partnership's goodwill. In my submission, it's just not open to them to do it. And as you've already got my submissions on the point, that the proposition that the partnership had any goodwill, just because of the nature of the orders that were being placed, the fact that ACON was a manufacturer that wanted to supply as many tests as possible. The idea that ACON had any call, the partnership had any call on ACON for its services just doesn't add up. Sorry. And I've already taken you to paragraph 427, where the judge set out what he considered was the partnership's goodwill, which was the partnership's name, being able to conduct sales over the Hughes Healthcare website and the telephone number. I've already said, and I just want to take you to the relevant documents on this. In the Appellants unagreed supplemental bundle, and also the agreed supplemental bundle. Let me take you to the agreed supplemental bundle because that would be easiest. At pages 2 to 16, the first letter in the stream is actually at the Appellants unagreed supplemental bundle at page 27.
Is it right? So just 427, you're skipping away from it. I mean,
Yeah.
Is the point you're making that the judge seems to take or treat the business relationship with ACON as something other than goodwill?
Yes.
I mean, he deals with them quite separately. He doesn't.
Yeah. Well, he also later on, and I'll be told what paragraph it is, suggests that other people may be business connections.
That's not the point I'm making to you. I'm just.
Yeah.
Just.
Yes.
Don't
No.
go
Yes,
off on
sorry.
that one.
Yeah.
I'm just.
Yeah.
Sticking to the concept
Yes.
of goodwill. Right?
Yes. If he thought that ACON was part of the partnership's goodwill, he would have lumped it in together.
So
with,
in 427 to A.
Yeah.
And you say that reflects the fact that he was never asked to consider the
Yes.
question about whether whatever the relationship with ACON was,
Mm-hmm.
not with the business connection.
Yeah.
It was part of the partnership goodwill.
Yes. So on the 22nd of April 2021, this is at tab 11 of the Appellants unagreed documents. There is the first letter from on behalf of the partnership complaining that that ACON had allowed another distributor, Medco Solutions Limited, to apply through the UK government's Department of Health and Social Care avenue to supply tests. So the partnership applied to supply tests to the government, and they were ACON tests, or Hughes Healthcare derived ACON tests, and Medco Solutions did the same thing. And so that starts off with the complaint, and then the following exchanges of correspondence are to be found at the agreed supplemental bundle at tab 1, tab 2 and tab 13. The the last one coming in on the 2nd of June 2021 from Alan Overy saying it's
Sorry,
you haven't
I've
got
got
the
lost.
case.
The
There we go.
we're in the agreed
Yeah, in
supplemental.
the agreed supplemental bundle,
it
and
was-
it's tabs 1, 2 and 3.
1, 2, 3. I see.
So the lawyers were involved
Yes.
between ACON and
Yes.
the partnership
Yes,
prior to the dissolution.
part of the dissolution, yeah.
Alan Newey acting for ACON.
I beg your pardon?
Alan Newey acting for ACON.
Yes, yes.
Detailed, yeah.
Saying it's not an exclusive
Yeah,
distribution agreement.
And that is a claim that Mr Manduka still wishes to pursue against ACON.
Hang on, when you say still, do you mean now or then?
Well, always, but now as well.
But what did the judge find?
Well, he found that Mr Manduka was the main proponent
No.
of the claim.
Did the judge make a finding about whether the arrangement between ACON and the partnership was an exclusive distribution agreement or not?
Well, he said that ACON was selective about who they distributed to.
Well, so that would be a no. Did he or did he not find that there was an exclusive distribution
If I can help,
agreement?
he said he was not going to make a finding one way or the other because he didn't need to for the purpose of his decision,
Couldn't find the paragraph.
as in terms of the legal exclusivity.
Right.
281. The relevant paragraph is at 281, my lord.
If Miss Hilliard will allow me, the specific answer to my Lord Justice Snowden's question is at page 110 of the core bundle, paragraph 126, where he says, "No one asked me to decide in these proceedings whether two bits of correspondence from ACON conferred on the partnership the exclusive right to sell ACON's test to the DHSC." He refers to some of the correspondence between Gardner Leader and Alan Overy. And then at 127, he goes on to say, prefiguring what he's going to conclude in paragraph 281 that Ms. Hilliard just referred to, "I'm satisfied that ACON was selective about who it supplied." And then he goes on to expand on that, but I'll sit down because I'm going to be taking you to some of this tomorrow afternoon, I hope tomorrow afternoon.
So my lord and my lady, just to make clear what paragraph 126 was talking about, it says, "No one asked me to decide in these proceedings whether the letter of notification and the letter of confirmation conferred on the partnership the exclusive right to sell ACON's test to the DHSC." One has to remember that was a letter of confirmation that related explicitly to selling tests to the government. When the judge referred at 127 to being satisfied that ACON was selective about who it supplied, and more specifically, ACON's business model was to supply its LFTs to a relatively small number of distributors in various jurisdictions. That wasn't for the purposes of making a tender or an application to supply the government. That was general distribution to the partnership, to NFL, to Medco, to, I think there were two others, to distribute the tests throughout the UK to people that wanted to buy them. So there were two things.
Well, yes, the 127 point is more about business model.
Yeah,
Acon wants someone else to do the running around.
Exactly,
in this
yeah.
jurisdiction to find
Yeah.
the buyers.
yeah, exactly. It's not that they were particularly selective about, I mean,
They just don't want to do all that work.
yeah, I mean, they were selective in the sense that I suppose they didn't want to sell, you know, the odd one or two tests to members of the public. But it's clear that that the partnership wasn't the only distributor. We know that Newfoundland became a distributor on the 14th of June, a direct distributor, and we also know that Medco was a distributor, and there were at least two others. So yes, they were selective, but any manufacturer, wholesaler, is going to be selective. They're not going. That's the nature of being a wholesaler that's using distributors to distribute their product.
You say it's not you say that this isn't an asset. Whatever the relationship was, it's not an asset of the partnership.
No,
Because you had no right to require
no,
people to sell to you.
no.
There's nothing exclusive to stop Acon selling somewhere else.
Yeah,
It's just, on the whole, they liked you. You're one of a few,
Yeah.
select few.
yeah, yeah.
And you say that you're going at some point to come on to whether that feeds into the definition of what business
Yeah.
connection actually means.
Yeah. And there's just one other point to bear in mind about goodwill, to the extent that it's going to be, the two other points. First of all, on the point about whether Acon post-dissolution sold to Mr. Hughes because of his relationship with the partnership, or whether it was just because they liked him as an individual. And you can see that from the finding that the judge made at paragraph 218 of the judgment, where he says that Mr. Hughes enjoyed, this is at page 127 of the core bundle, he enjoyed a warm relationship with Anita Shway, in contrast to Mr. Manduka's frosty relationship with her. That was partly because Mr. Manduka had shown much more interest in taking legal action against Acon for its asserted breach of the exclusivity arrangements, whereas Mr. Hughes, that's the exclusivity in making tenders to the government, whereas Mr. Hughes was more emollient on this issue. However, there was a personal element too. Anita Shway admitted to Freddie Manduka in a WhatsApp chat on the 6th of August 2021 that she liked Mr. Hughes much more than Mr. Manduka because she perceived that Mr. Manduka and Mrs. Manduka adopted a hectoring and demanding tone with her, which Mr. Hughes did not. Mr. Hughes leveraged that warm personal relationship to seek to persuade Anita Shway that because, as he said, he owned the Hughes healthcare brand, Acon should not supply either Newfoundland or the Mandukas with the branded LFTs. That's, of course, different from the question of whether Mr. Hughes leveraged any partnership goodwill that it had with Acon. There's a final point on goodwill, which I've mentioned before, but it's good to bear it in mind. Prior to the 14th of June, by far the greatest numbers of orders placed by the partnership with Acon were made on behalf of Newfoundland. Newfoundland was a distributor of the partnership, or a sub-distributor. However, the partnership, as we know, agreed as of the 14th of June 2021 that Newfoundland could go direct to Acon to place the orders. So from the 14th of June, the most significant part of the partnership's turnover from orders that it had previously placed with Acon disappeared practically overnight. So we say the goodwill point that was raised for the first time 6 weeks ago is, for the reasons I've just explained, a bad one. The partnership had no goodwill with Acon. Moreover, even if you could say it had some goodwill, and we say it doesn't, Mr. Hughes didn't derive any benefit post-dissolution from the use pre-dissolution of the partnership's relationship with Acon. He didn't secure pre-dissolution contracts with Acon that were completed post-dissolution on the back of any goodwill with Acon, and the judge didn't find that he did.
Somewhere in the authorities that we saw this morning, there was, I think, a definition of goodwill offered, or at least some. I don't know whether anybody sitting alongside you or behind you can remember where it was. What do you understand to be the meaning of goodwill?
I think what I understand. Well, it's a. I mean, we kind of have looked at this, but it's a somewhat
Law's authority on it.
Yeah. I know, I just can't remember where it is.
It comes up in tax, doesn't it?
Yes, it comes up in tax.
I mean,
Called Miller's margarine is
Yeah.
the
Yeah.
I mean, there's certainly a number of them that I've seen. I mean, the common feature is that I think it's an asset of the company.
Yeah.
Whether or not included with a number attached to it in the balance sheet, usually not.
Not, yeah.
I know there is dog goodwill and cat goodwill. At least that was the old types of goodwill, but it's generally, as I understand it, the tendency of people to either return
Yes.
to the place or to the people to do business with the entity.
Yes. Well, that.
That's I think my basic
Yeah.
understanding of what goodwill is, but there's been a number of different definitions somewhere along the line. But I wouldn't mind at some point since we've got into this goodwill,
Yeah. Well,
to
yes.
say what it is you say it means and why you say whatever the relationship with Acon was, it wasn't goodwill.
Well, we mentioned Pathirana at tab 71 this morning, the Prison Council decision. That page 2094, internal page 240. Where it said that Caltax was content to let the partnership continue trading on the premises for some years, so the firm was able to build up a substantial business at the service station. This brought with it substantial goodwill, namely that is the possibility of customers returning to the premises for more petrol, especially as, according to the partnership agreement, they were the sole agents for their district of Caltex products.
The point being, the goodwill there is identified as customers coming back,
Yeah.
which is the
Yes.
conventional usage.
Yes.
It's not suggesting that there was goodwill between, in this case, the partnership and Caltex.
Yeah, and the reason why we say that it's difficult, well, almost impossible to say that there is any goodwill with a supplier like Acon is because no long-term contract, Acon can decide to switch on or switch on their supply of goods at any time. They can choose who they supply with. There is nothing that the partnership can do other than perhaps pay for their supplies of tests on time. And even that I don't think would amount to goodwill, because what would happen is that the Acon would simply stop supplying.
Could you not put some of those same points in relation to customers where, on any view, there can be goodwill? I mean, suppose you don't have a long-term exclusive arrangement with a customer. That doesn't prevent goodwill?
No, but I think a customer is a different idea, because the customer comes back, as Parathana says, comes back to the same place. It's on their route, as it were. There's a much more obvious opportunity for adhesion, if you like, by the customer to the supplier, to the, in this case, the gas station, and particularly when the gas station was a sole agent. I mean, nobody else in the vicinity were offering Caltex products. So the customer had to go there. Aecon doesn't have to go to the partnership to sell its product. If customers wanted to buy Caltex products in the immediate vicinity, they had to go to that petrol station. So it's different. That's why I think, you know, Aecon held all the cards, and it's very difficult in those circumstances to see how the partnership could say that Aecon has some kind of adhesion to us because we are one of 5 distributors. There was nothing that the partnership was doing that was particularly special or novel that would drive Aecon to want to use the partnership as opposed to any other distributor. So we set out the reasons why we say Section 29 was not engaged post-dissolution at paragraph 23 of our skeleton. And that was, and that's really sort of coming on to, if we're exploring goodwill, which we say there was no finding to that effect in this case. The partnership business had involved the buying and selling of Hughes Healthcare branded LFTs by a series of one-off discrete transactions, and the name and goodwill, which were the name and goodwill, which were the only assets of the partnership, had no influence on the ability to place discrete orders with Aecon, the goodwill as found by the judge. Mr. Hughes did not, post-dissolution, appropriate for himself an asset of the business, such as a lease or long-term contract, including by renewal. There was no ongoing long or even short-term contract for the purchase and supply of LFTs, which Mr. Hughes appropriated for himself post-dissolution. No issue arose as to completion of contracts uncompleted at the date of dissolution. There was no need to continue the business for the purpose of its realisation or for the sale of the name or goodwill in the course of the winding up. And I mean, this is a point that is really more for Section 42, but after dissolution, the former partners, I think it's one that Lady Justice Falk has raised, after dissolution, the former partners both carried on their own businesses. Mr. Manduka through Hughes Healthcare Limited and Newfoundland, and Mr. Hughes through HDL for a very, very short period, and then MSDL, both buying and selling LFTs from Aecon in circumstances where there was no legal restriction on them doing so. Both partners knew that the other was going to be carrying on a business buying and selling LFTs post-dissolution. As the partners did discuss but didn't resolve who should take over the benefit of the partnership. And as we know, the authority of the partners to enter into contracts on behalf of the partnership came to an end as a result of Section 38 of the Partnership Act. So we say you've got a situation where both Mr. Hughes and Mr. Manduka are both carrying on separate businesses post-dissolution that simply didn't engage Section 29 or any fiduciary or good faith obligation, because it involved no conflict of interest or exploitation of their fiduciary positions, given effectively that the business had ceased, but the two partners were going off and doing effectively the same business on their own. And we say that the judge did appear to come close to accepting that last point when he found at paragraph 264 he observed in relation to Don, King and Warren, this is at page 137 of the core bundle, Mr. Warren's fiduciary obligations had to be applied in circumstances where he and Don King Productions were no longer carrying on a business with a view to profit, but rather winding up a partnership that had been dissolved. In circumstances where there was to be no ongoing relationship between Mr. Warren and Don King Productions, I can quite understand why Mr. Briggs accepted that Mr. Warren's fiduciary obligations precluded him only from pursuing for his own account opportunities that ultimately derive from contracts of partnership. So the judge, we say, came close to accepting the point that if the partnership has ceased and there are new opportunities that come along that are not derived from contracts of the partnership, which was not the case here with Acon, then the judge seemed to accept what was conceded in Don, King and Warren, that there would be no obligation to account. We referred to a textbook by Professor Drake at tab 89, page 192, internal 229 PDF, where third from the top of the page, he's talking about use of partnership, property name or business connection, and he refers again to the expiry of a lease granted to the partnership and refers to Featherstone, Howe and Fenwick, and refers to entering into a lease openly and after notification of intention to do so to the other parties, as in Clegg versus Fishwick. And then he describes the renewal is seen as a graft or addition to something which is partnership property. And we rely on that, because what we say is that there was nothing that Mr. Hughes did which could possibly be characterised as a graft or addition to something which was otherwise partnership property. Now, coming on to ground 1C now, where we say that the judge was wrong to find that Acon was post-dissolution, you'll be pleased to see that, my Lord Justice Snowden, was post-dissolution a business connection for the purposes of Section 29. The judge should have held that from the date of dissolution, Acon was not a business connection of the partnership that was exploited by Mr. Hughes. Now, by way of introduction, it's necessary to stress the obvious point that liability under Section 29, or any good faith or fiduciary obligation in respect of the use of a partnership business connection, does not only depend on the identification of whether a partner has used a partnership's business connection in the abstract. And for that, we refer to the case of Ass and Benham and also Dean and MacDonald. Ass and Benham, which was at tab 19 of the bundle, was a case where it was held that a partner in a firm of shipbrokers who assisted in the formation of a shipbuilding company was not required to account for any benefits received from the shipbuilding company, even though he'd used information received in his capacity as a partner of the shipbroking firm. At page 256 of the judgment, which is page 280 of the PDF, Lord Justice Leanley said, there is no principle or authority which entitles a firm to benefits derived by a partner from the use of information for purposes which are wholly without the scope of the firm's business. And there was an earlier case of
Just pausing there.
Yes.
Why is this in point at all?
Well, because we'll come on to 1D.
But so we're at the moment on 1C.
Well, I was introducing 1C, and I was pointing out maybe the obvious.
It's perfectly true that your fiduciary duties can be circumscribed by the
Yes.
scope of what you're dealing with.
Yes.
But that's not really what we're concerned with here.
Well, no, I agree, not on this ground, but I was doing it by way of introduction to clarify or to make clear. I mean, obviously it's clear to your lordship, but just in case it wasn't clear. I mean, that there is. It's not every use of partnership property which will inevitably require an obligation to account if it's used in a way that isn't, which is out with the scope of the partnership's business.
Well, you say that, you assert that. I mean, as I understand it, you get to 1C. Is this right? You're going to make submissions on 1C on the footing that you're wrong on your previous grounds, aren't you?
No, we're saying that the judge was wrong to find that ACON was post-dissolution of business connection for the. I mean, it's all of a.
But I mean, sorry. I mean, the reason we're going to Ass and Benham is that's a fiduciary duty case, right?
Well, yes, it's a case which says if it's not within the scope.
But let's assume you're wrong.
Yeah.
And that the judge is right to say, look, I just look at section 29, it either falls within the words or it doesn't.
Mm-hmm.
Are you going to start by actually telling us what you
Yes.
what you think, what the judge thought he meant by a business connection and what you submit a business connection actually is? Because speaking for myself entirely, I actually, can't find where the judge actually told us what a business connection is.
He doesn't.
And I would appreciate your assistance on telling me what you think it is.
Well, what we say, business. All right. Well, I'll come back to what.
Am I wrong, or is that not the starting point for a submission at 1C? That you say the judge was wrong to say that ACON was a business connection of the partnership. You've got to start by saying, well, what does it actually mean?
Just before you help me answer my lord's question, you were going to take us to two authorities. Shall we get the authorities out of the way? So you've taken us to the one. The other was.
The other one was Dean and McDowell, which is a case where. And
that's at tab.
That's at tab 15. Where there it was held that there was no obligation on a partner in a firm of salt merchants and brokers to account for profits he made in the business of salt manufacturers.
So this is similar to the last case?
Yes, yes. So
yeah.
So I mean, what we say is that the position in relation to partners shouldn't be any different from the position of directors in this context. So if one looks at Regal Hastings and Gulliver, which is at tab 23, Lord Russell spoke of those, this is at page 144G, that's where the judgment is, and then, sorry, at 144G, Lord Russell spoke of those who by the use of a fiduciary position make a profit, and at 153D, PDF page 336, Lord Macmillan referred to fiduciaries being accountable for profits if it was by reason and in virtue of their fiduciary office as directors they entered into the transaction. And then similarly in recovery partners,
Sorry, just before you
Yeah.
go there, I didn't get the references, so can I
Sorry.
just get them?
yeah,
Which
It was-
passages are you relying
it's
on?
tab
Yeah,
23,
I've got that.
and I'm referring to 144G and 153D, internal paging.
144G. Sorry, the second one was
153D.
Using their fiduciary position to
Yeah. And then,
So this is Channon Sicario, so to speak.
yes, and then, although Recovery Partners wasn't a partnership case, we do rely on what Lord Briggs said, that's Recovery Partners. Tab 64, and we rely on what he says in that case at paragraph 4. Where he says, where profits are only made by the fiduciary after the fiduciary relationship has ended, the fiduciary will still owe a duty to account if the profits have been derived from or made out of that former relationship. And what we say here is that just because Mr. Hughes purchased tests from ACON, it's impossible, and the judge didn't find that Mr. Hughes derived his profits from the partnership's former relationship with ACON. And then he goes on, typically the profits may be attributable to the development of an opportunity which the fiduciary learned about while performing his fiduciary role, or have been facilitated by the use of information which he received while acting in the same capacity. And when it says information there, it must mean confidential information. I mean, the information that there is a supplier called ACON of tests is not confidential information. And then at paragraph 25, he said, the director of the company may, after resignation, set up and make a profit from carrying on a similar business to that of the company, provided that he does not use information or pursue opportunities that came to him from his fiduciary position in the company.
That last one is from paragraph.
It's paragraph 25 of Recovery Partners at tab 64.
Sorry, can you tell me how that helps the definition of business connection?
Well, because what we say is that there can't be a difference, or there should not be a difference between what a partner has to account for post dissolution and what a director has to account for post resignation. They're both, they're both commercial structures. Partnership law preceded company law. Company law sort of was a development from or the obligations owed by directors was a development from the law of partnership. And if in terms of testing whether what a business connection is, in terms of testing what a director needs to account for, it gives you a good idea about whether, in this case, a supplier called ACON is something for which, if a director wouldn't have to account for placing multiple orders with a supplier post resignation, we say, just as strongly, a partner shouldn't be in any worse position. And in fact, it might even be argued that in the case of a dissolved partnership, the position should be less strict, because the rule in relation to a resigning director normally applies where the company is continuing in business, and so the company is directly prejudiced as a result of the director resigning in order to exploit an opportunity that should properly be the company's opportunity. But in this case, there was no ongoing business for the partner to protect. And I've already mentioned the sole duty under Section 38 is to complete uncompleted transactions and wind up the partnership's affairs. There are two related points to be made here as regards the partnership. First, in 2021, there was a pandemic. It was in the public interest that there should be a plentiful and efficient supply of tests.
You're going on to the facts of this case.
Yes.
Can we?
Yes.
Okay, I'll just ask it again, but you said the judge didn't define what he
No, he
meant by
didn't.
business connection.
What one can only really, I think,
Do you have anything to offer us?
well, what the judge held, what he held, without explaining what he meant, was that ACON was a business connection.
Yeah, and he said it's a question of fact and degree,
Yeah.
but he didn't tell you what you were looking
No.
for,
No, he
which
didn't.
I find difficult.
Yeah.
So I'm really asking you to help me. What should a judge look for when they're looking for a quote business connection
Well,
within the meaning of Section
Yeah.
29?
I think it's quite close, or probably is, in the nature of goodwill. But goodwill, goodwill isn't actually referred to in Section 29, but it is a willing. It's a partner who is relying on an ability to get business from a third party and wants to say that it is goodwill, has to be able to demonstrate that the relationship with the third party is of sufficient substance that it can compel or encourage that third party to want to do business with them, on an ongoing and long-term basis. So the obvious.
Just to qualify, to
Yeah.
be clear, do you not need to put stress on it being a business connection of the partnership?
Absolutely, it's a relationship that the partnership has with
By
the
definition, not other people.
no, not other people, with a third party, and that relationship has to be of sufficient substance that the partnership, the partnership can effectively treat it, the relationship, as belonging to it, so that when Lady Justice Arden was talking about the relationship that the partnership had with the EDLC in the John Taylor's case, she stressed how long that the relationship had been in existence, and the fact that it was exclusive, that there was only one livestock stock market, and therefore it was something that the partnership. Lady Justice Arden said it's equivalent. You can treat it as equivalent of partnership property. The relationship that you don't want me to talk about ACON, but by comparison, the relationship that ACON had.
If you wanted to talk
The
about
relationship.
ACON, but I'd quite like to talk about business connection first.
Yes. Well, I mean, the only way I can describe it, and it has to be by reference to the John Taylor's case, because that's the only thing that really comes close to it, is that the business connection has to be something that the partnership can actually call upon in a way that belongs to it, it adheres to it, rather than something that is potentially as ephemeral and short-lived as a 7-month opportunity to purchase tests from a supplier. It has to be more than that, because otherwise the net effect is that informal partnerships that set up all over the place, the partners will be precluded post dissolution from carrying on the same or similar business. And yet, I mean, it happens all the time that two people come together, they come together, they create an informal partnership. It doesn't last very long, and then they go off their separate ways. Is it really to be said, for example, that because the partnership had a relationship and was purchasing wholesale from a particular supplier, if it's a carpentry partnership, the partners cannot go off and continue placing orders for wood from that supplier. And so there is no definition of business connection. There's lots of attempts, and what we say is it has to be something that could be characterised as belonging in some way, belonging to the partnership.
When you say lots of attempts,
well,
attempts in the decided cases.
No, the textbooks. If I took you to the textbook where I think it was Professor Toomey talked about something being grafted on to what would otherwise be partnership property, and then of course there is John Taylor's where Lady Justice Arden, talked about it being a connection because it was very long-standing. Parithana talked about it being, I think, a business connection, although it was very tenuous. Well, it wasn't so tenuous because the petrol station run by the two partners was an exclusive license from Caltex, and customers, if they wanted Caltex's products, had to go to that station. Here, there were distributors other than the partnership, and as I say, there was no way that the partnership could effectively get ACON to adhere to it for the purposes of a relationship with ACON. They were entirely at the whim of ACON. ACON held all the cards, and so, for those reasons, we say that the partnership had no business connection with ACON. One can see the way in which.
Well, it's one way of looking at this to say you've got to interpret, you always have to, these provisions purposefully. What are they getting at? I know this may overlap with grounds 1A and B, but you can perhaps even see within the wording of section 29 that this phrase appears at the end of the list.
Yes. Yes. Well,
aren't there points around that as well?
Well, that is probably was going to come on to it. But, it's the end of a short list, to be fair. But it does say, obviously, partnership property is property. The partnership name is property, and so business connection would be something akin to property, which is why Lady Justice Arden says we treat it as property. And of course,
treat it as an asset.
no, I think I'll have to find it, but she actually says we treat it, well, maybe she treats it as a partnership asset rather than a partnership property.
It may be quite important to look at that.
Sorry. Checking if it's open on now.
You may be right, I may be wrong.
I'm being told from behind it's an asset of the partnership rather than,
But I thought,
yeah,
see, paragraph 31, she says, likewise, the goodwill of the partnership,
yeah,
its business connections generally,
yeah,
were an asset of the partnership.
Yeah.
I mean, we don't know because this is an extemporary judgment.
yeah. Yeah, I'm happy to accept that she, Lady Justice Arden at paragraph 31, appears to be treating goodwill or business connections as if it was goodwill.
Well,
But it's not absolutely clear, is it? But she does say, likewise, the goodwill of the partnership, its business connections generally. So it may be that, well, it looks like that what she is doing is,
I mean, she starts at 29 and she says, here are the essential steps in the argument.
yes,
First, the opportunity to renew the licence or obtain a new licence was an asset of the partner.
yes,
And second, the relationship which the old partnership had with the ELDC was a business connection.
yeah,
Explain why it's
No.
a business connection.
but
It
she,
says, likewise, the goodwill of the partnership, its business connections generally were an asset of the partnership.
yeah. Well, I think that she probably, if you look at paragraph 32, she regards the customers as being business connections because she refers to counsel for the partners ignoring the fact that LMA had goodwill with its customers.
And also the opportunity to renew.
The licence by reason of its relationship with ELDC, which was, and I've emphasised this before, of a very long-standing nature.
When you go back to section 29 and the words that my lady was focusing on, its use of the partnership property name or business connection. It's inherent that there's some degree of belonging or possession
Yes.
or something in partnership property. I think that is inherent. Partnership name, well, in a sense, it's the right to use it to the exclusion of others, you would think. And partnership business connection. You say it has to belong in some way. I mean, do you have to go so far as to say that it's actually an asset in the property sense of the word? So property in that it can be put onto the balance sheet or protected against other people? Or are these just indicia of...
I think it's in, because I think Lady Justice Arden, the provisional licence wouldn't ordinarily have been partnership property because the partnership property was, the lease was still in existence at the date of the dissolution. So they got a provisional licence post-dissolution.
The opportunity to renew it.
Yes.
That's what and that's effectively akin to goodwill because that's where it's the supplier attraction in that case. I mean, section 29 obviously doesn't use the word goodwill.
No.
And at that time, I don't think there were cases saying that goodwill is an asset. There are now
That's interesting.
plenty of cases that describe goodwill as an asset. Maybe Lady Justice Arden was reading
Yes,
section 29
that way.
in modern from a modern perspective.
Yes.
I mean, is it something that you can protect against other people?
No.
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 So,
Well, what
So the
are
question-
you asking? Goodwill? Can you protect against that? I thought. Sorry. Yes. Okay. Well.
no, I mean, in the loosest in a sort of very literalist sense, you know, I have a business connection. If I
Yeah.
buy a pen from a shop,
Mm-hmm.
I mean, I have bought one of their items for sale in the course of their business.
Yeah.
It might be said that's a business connection.
Yes.
You know, if I use a pen in my business, I go and buy it. I mean, is that a business connection
No.
within the meaning of this?
No.
So what are they driving at with these words? And that's really what I'm certainly trying to grapple to find my way towards.
Well,
Because it's something more than
Yeah.
just having run across them
Yeah.
in the course of doing a business.
I mean, one consideration might be it's not. I mean, it's not definitive on saying what a business connection is. But for example, could Mr. Manduka have applied for an injunction to restrain Mr. Hughes from placing orders with ACON? And
That's another way of expressing the same question.
Yeah.
I mean,
But yes, but if you test it that way, it does seem somewhat implausible that on the basis of the fact that ACON wanted to sell tests and were willing to sell tests to anybody that would be willing to distribute them, that the partnership had some kind of exclusive property. I don't mean property in the, but exclusive right to place orders with ACON.
Well, it clearly didn't because
No, it
the
didn't.
government had it.
And that's why I say it's not a business connection. I mean, just to finish on where the judge was coming from, the judge found not only that ACON was a business connection, but also an individual called Daniel Butcher was who.
Although he didn't. He didn't say.
He said possibly.
Yeah.
Yeah.
Well,
But without explaining why.
I was going to come on to that because, I mean, that in itself, I mean, the mere fact that he would regard it as DB, as he calls him, as potentially a business connection, and he says, I don't need to decide it.
Well, it is important that we get to a landing place on this because we're heading at the moment to a second trial, and at the moment, questions like that are still up for grabs. It will be an issue in trial 2 as to whether Mr. Butcher.
Was there any argument about whether DB was a
No,
business connection?
No, there wasn't. No, it wasn't pleaded because business connection wasn't pleaded, but there was never any argument about. It was never advanced by Mr. Gorgie, as far as we recall on this side, that any of these further individuals were business connections. That was something that the judge unilaterally.
Because on the face of it, if that person was a quote business connection, then even though face of it, you couldn't seek to do business with them and get their assistance.
No, and Polly Phillips, she was. I don't think she sold any tests prior to dissolution. But
these aren't employees of the partnership.
No, they weren't employees. They were just independent agents.
Give me the dates of this contract.
Yeah, they were friends of Mr. Hughes, really. Lost me. I mean, the best that we can say is that if you have a short-lived, non-exclusive, incapable of I can say what a business connection is not. If it's short-lived, non-exclusive, incapable of monetisation on its own, and incapable of being realised for any monetary sum for the benefit of the partnership post-dissolution, whether that's by, you know, introducing the business connection to a third party and asking for money for it or something like that, that is not a partnership business connection, that it has to be something that has that and I accept that the judge said it's a matter of fact and degree, but before you get there, you have to work out what a business connection is. As Lady Justice Falk said, it is true that it talks about partnership property, which is obviously an asset of the partnership, the name, which is an asset of the partnership, business connection. So one would say, you know, justem generis, it must be of the same nature. Whether it only means goodwill, one can't say, but as goodwill, I suppose goodwill might otherwise be subsumed in partnership property, but as Lady Justice Falk told us that goodwill wasn't something that was a familiar concept in 18.
The House of Lords decision I was talking about was 1901. So
Right.
after this.
Yes. Yes.
It's a tax
Yeah.
case, of course, but it's House of
And
Lords
what was the
decision.
name of the?
Fuller's Margarine, 1901
Oh.
cases.
My junior's saying she knows it, so we've obviously looked at it. So
1901 AC 217.
Yeah.
It's been used. It's been, if it's of relevance to anyone, I know there's a more recent, talking of cat, dog, etc.
Yeah.
Goodwill. It's
Yes.
considered in their case.
yes, I
called
do remember the cat and dog.
Kirby and Thorny
Yeah.
and I, which is 1980.
Yeah.
It's one we use.
So going back though to the point, obviously you want to try and get to the bottom of what business connection means, and I can only, I mean, all I can say is that it must be, we would say it must be of the same nature as partnership property, partnership name, because it's, in those circumstances, it's very easy to see why a partner should account for the unauthorised exploitation of them. What we say is it's very difficult to see how a third-party supplier of such short duration could, who, as I say, not exclusive. There's no way of this partnership being able to leverage any exclusivity from this supplier. Could be seen should be treated as being the partnership's business connection, and that in circumstances where the term is very unclear, a way of approaching it is to look at it in the same way as company law looks at maturing business opportunities, which are developed during the existence of the directorship, or in the same way as goodwill is regarded now. But, as I say, that was never their pleaded case. And if it had been pleaded case, maybe the case would have gone in a different direction, but it wasn't. And the judge did not find, A, that ACON was a business connection, and, that ACON was part of the partnership's goodwill, and secondly, that the judge didn't find that Mr. Hughes leveraged the goodwill, if that's what it was, that the partnership had with ACON for the purposes of placing orders and paying for orders and post-dissolution. And we do point out at paragraphs 38 to 41 of our skeleton, and it's obviously something that probably is troubling you, but the judge dramatically extended the duty to account for post-dissolution benefits under section 29. I mean, far beyond any of the cases that the court, that we took you to earlier, where there is an obligation was found to account for post-dissolution profits. And the difficulty is that the judge's approach risks any partner being subject to a claim for both post-dissolution profits simply because the former partnership had some dealings with a third party. And we say that can't be right. Another point that we make at paragraphs 37 to 48 of our skeleton is that ACON was not the partnership's business connection on the facts found by the judge, because merely because the partnership placed orders with ACON prior to dissolution does not, we say, result in and of itself from Mr. Hughes having a duty to account for post-dissolution for the orders he placed with ACON, unless by placing those orders, Mr. Hughes misused his fiduciary position. And that could have only have happened if the benefit he derived from the orders placed with ACON post-dissolution were orders made as a consequence of the use of the partnership's relationship with ACON. And that was not a finding that he made. And therefore, this court should not be making such a finding now.
That's back to your ground 1A.
Yes. And we do rely on the fact that ACON was, after all, in the business of selling tests. And there's no reason, absent the fact that they didn't like Mr. Manduka, that ACON wouldn't have sold to Mr. Manduka. Indeed, as Lady Justice Falk has pointed out, that in a way they did sell to Mr. Manduka, because, as the judge found, Mr. Manduka was in partnership with his son and his son's friend. I mean, that was an express finding of the judge, and therefore post-dissolution, when ACON was selling tests to Newfoundland, they were also selling tests to Philip Manduka. And what we say is that the position is similar to the finding in Cheshire Estate and Legal Limited versus Blanchfield, which is at tab 61 of the bundle. This was a judgment of Lord Justice Phillips, with whose judgment Lord Justice Snowden agreed. And at paragraph 36 of that
Sorry, I missed the.
Yeah, it's tab 61. And it's paragraph 36. It's a small point, but Lord Justice Phillips rejected the proposition that the directors' dealings with a litigation funder while they remained directors of a company constituted a conflict of interest because, as he found, there was no evidence that the litigation funder would not have worked with both respondent former directors and the company after the director's resignation. So, and actually the evidence before the court was that indirectly Aecon was supplying Mr. Manduka because, as the judge found, Mr. Manduka was in partnership with his son and his son's friend.
Well, put it another way, Mr. Manduka wasn't himself trying to do business of this kind except through Newfoundland.
Yeah. I mean, he started off selling tests to one of the partner's customers, Collinson's, but as far as we can tell, that didn't go much further. So. What we submitted to the judge was that as a matter of construction, this was at paragraph 44 of our skeleton, a business connection must be derived from the assets of the partnership.
Sorry, paragraph 44.
Yeah, 44 of our skeleton, which is the core bundle, page 45, I think. Sorry, I think that might be where he rejected the argument.
Is this your skeleton for us or your skeleton below?
Sorry, this was a skeleton for here, and I've just let me. Yeah, it's tab 3, page 45. Yes, what we say in our skeleton is that the judge was wrong to reject the argument that as a matter of construction, a business connection must be derived from the assets of the partnership. That was at paragraph 282 of his judgment.
What do you mean derived from the assets?
Well, I think what we were trying to say there, although
if I have an exclusive distribution agreement with you,
yes,
is that not business connection for the purposes of this?
yes, I think if there was an exclusive distribution agreement, I think, I think.
I mean, you might say that. I mean, in a sense, that's partnership. It's a piece of
Partners,
property.
yes, exactly. Yeah.
But if it's not realisable,
Even if it's not realisable, I think that it could still be partnership property. I don't think because, well, for example, goodwill isn't necessarily realisable.
I think the point is you can, if it's exploited in some way,
Yes.
the relationship relating to that exclusive agreement is exploited, most obviously by taking a renewal.
Yes, yeah, and I think one.
Can I just be
Yes,
clear?
sorry.
Well, to this extent, are you saying that a business connection must be property of the company?
No,
You're not saying that.
no, we're saying it must be derived from the assets of the partnership. That's what we were trying to.
what does derived from mean? Though I just
Well, sorry. Yeah. Well, I think we got that from Linley and Banks. It's because that's where that statement comes from. That appears at tab 106 in Linley and Banks' 21st edition, paragraph 1670. Yeah, sorry.
So which Sorry,
So
but
it's tab 106, and I'm afraid
Yeah.
it's
Yeah.
so it's at paragraph 16-70. So it's quite a long way. It's
yes.
internal 2431. And what Lily says is that if a partner continues in business following the dissolution of his firm and makes use of the firm's assets or a business connection derived therefrom, he will be accountable to his former partners for any profits which he may make thereby. So using my lord's analogy, if there was an exclusive distributor agreement, but the partner didn't make use of that exclusive distributorship agreement, but did seek to leverage the partnership's relationship with the other party to the exclusive distributorship agreement, then one could say that it was a business connection derived from a firm's asset, namely the exclusive distributorship agreement. But the business.
I mean, those words, that concept doesn't. I mean, that's just putting a gloss on the words of the statute, isn't it?
Well, it is, but it's obviously the authors, which, I mean, this has appeared
Well, I think I mean, you have to look at what's said there in the context of the cases that are then said to illustrate it.
Yes.
And I think it may be no more than the point you've already made. If you look at the cases, I think myself, I think Linda's trying to describe the sorts of things that have been found to fall
Yes.
within this. And the editors refer to 3 cases which we've looked at.
Yes, yes. Well, and this case doesn't
All
come.
of them essentially dealing with renewals.
Yes,
So the partnership
yes.
asset is the license or whatever it was.
Yes.
And there's a renewal. That's not necessarily an exhaustive statement.
No, I accept that. But I think it's significant that Linley. It's a text that's been around for many years, and that statement has been around at least since 1990.
What you have said a couple of times is a phrase
Yes.
which I stuck with me slightly, which is leveraging a
Yes.
relationship with the partnership.
Yes,
There's a sort of connotation of getting something that you shouldn't get
yes,
from the partnership
yes,
assets.
yes, yes. Well, but then, I mean, maybe that I'm not using the right term, because then I think one would have to go on to say, well, why? What was the leverage that should have been that he shouldn't have used? Why shouldn't he have leveraged the relationship with the partnership? And I think one goes back is that you have to look at the relationship's partnership with the third party and say, is that something that if it wasn't an actual partnership asset, was colloquially something that the partnership could look to as belonging to it and capable of exploitation in some way. So that if, for example, Acon had permitted and agreed with the partnership that it had exclusive distribution rights of its tests, and that agreement continued for quite a long time, then if the partnership was dissolved and Mr. Hughes went to Acon and said, well, now I want you to supply me, even though there was still an agreement in existence with the partnership which might be capable of being leveraged because they could find somebody and persuade Acon to carry on the distributorship agreement with them, that then in those circumstances it would be the use by Mr. Hughes of a partnership connection. I think.
We're past 4:15.
Yes, I'm sorry.
So shall we break and start again at 10:30 in the morning?
Yeah, very well.
Before you rise, can I just put down a marker about the time, because we're, I think we're in 1C, although I occasionally get a little unclear. If we follow the guidance that you gave, I'll be on my feet. What I've just to put my cards on the table, what I would be, I'm sure my clients would be unhappy if my learned friend ran a long time into tomorrow afternoon. I then had to finish sometime on day 3 to give her a little bit of time to reply, and I'd found myself truncated, as it were.
We'll see how we go.
I understand.
Where is it?